Yeah, let me just round off with my last point, which is simply to say that maritime arbitration, I was saying, is very much document-based. It is very amenable to digitalization. But more generally, I think that as lawyers and judges and people who are in the legal industry, we need to join into the conversation in relation to how we use digitalization to do dispute resolution. Otherwise, we will be disrupted as a whole. So my invitation to all of us is actually to get involved into the conversation and influence this space rather than leaving ourselves as victims to others. On that note, I will end here and invite comments and observations. Of course, I wait to hear from Nick immediately after this. Thank you.
Well, thank you very much. I hope I can be both seen and heard, and no doubt I will be good. I will be told if not. A few observations from essentially, I suppose, a London point of view. I think over the last, 5 or 10 years, I think there have been two things happening in parallel. One is the developments with document handling systems, and we've all moved to really to e-disclosure, but then for hearings to some really fabulously sophisticated document handling systems. So that, for instance, you can have a witness giving evidence, everybody on the screen at the same time is taken to the document that the witness is being asked about. There's a transcript being produced as things go along, and the transcript is then linked to that document, so that later on when you come back to read the transcript on your laptop, you can remind yourself of the document the witness was talking about. That's an extraordinary development. It doesn't necessarily mean that things have to be done remotely, but it enables things to be done remotely. So that's been a great facilitator. And at the same time, I think really because of the pandemic, we have all learned to use Zoom or Skype or Teams or whatever it is to do the other thing which we need to do, which is to get over the problem of people who are in different places not being able to speak to each other. And I think the way in which those two things have come together is what has really, in the last 2 or 3 years, made the possibility of effective remote hearings a reality. I've just come out of an arbitration, which was a kind of hybrid. And I know there are some sort of students and people listening who are not so familiar with international arbitration. I'll very briefly describe how it worked. We had in a room in London the 3 arbitrators and the counsel who were appearing in the arbitration. The instructing solicitors were not present in the room. One was, my solicitors were in Shanghai. The other side solicitors were in London, but didn't come to the hearing. And then we had a big screen in the room, which had witnesses and simultaneous translators translating at the same time. And then parallel with that, we had document handling system and someone who would bring up the documents as they were referred to, and a transcript going on and linked in the way I've suggested. Now that worked, I thought, extraordinarily well. But do note that it was in part a hybrid, because there were 7 people in the same room. And I have to say, I think that fully remote hearings with every participant in a different place are a real challenge, remain a real challenge, and maybe not as effective as something which is hybridized. But I have to say, I think the days of witnesses flying halfway around the world to give evidence for 3/4 of an hour, I think those days are pretty much gone. So we are moving into a new era, I think. The courts are doing similar things, of course. They've had to do similar things. I think there is a difference between court proceedings and arbitral proceedings because court justice at root is supposed to be done in public, and arbitrations essentially are private and behind closed doors. That's one of the great attractions for many participants. I personally am a bit unhappy about the idea of lots of court proceedings being done online, because although in one sense it makes it easier for people to see what's going on, it excludes those who aren't online. There's a flip side of that, which is that I think in arbitration we have to be careful, because as soon as proceedings are online, it is terribly difficult to be confident about confidentiality, because anything online pretty much can be recorded, very difficult to stop it. And that is potentially a very straightforward way for confidentiality to be breached. And I think we need to think maybe a little bit more carefully in the arbitration community about just what controls and perhaps what undertakings we need to take from parties and participants to ensure confidentiality. I'm not aware of any problems yet, but I foresee there may be problems with that. Final point on AI, and this is Leslie's, I think, most interesting point, maybe most contentious point. Let's just begin with Go and chess. Extraordinary what computers have done playing Go and playing chess, but they are complete information games. There's no guessing in either of those games. You can see the board. Computers are not so good at playing bridge. Actually, the best bridge players in the world generally beat the computers. So I think artificial intelligence and what computers do is extraordinarily powerful where there's complete information. But the thing which I think people bring to the process, they bring when information is incomplete. And that is maybe the thing which we give a label to, which is judgment. Judgment is slightly at the end of your fingers, what exactly judgment is. But I think often it's getting the right decision even though you don't have all the information. So I agree that AI is something we must be aware of and sometimes embrace and sometimes use as a tool. But my own feeling is that it is unlikely it will substitute for human decision-making, at least in cases of any substance. But the jury is out. And in the past, people who have been doubtful about what computers would achieve have generally been proved wrong. So I wouldn't be surprised if in 20 years, somebody goes back through the records and the YouTube videos and they find Vinyl spouting absolute nonsense about the scope of computers to resolve disputes. So that's my comments.
Thank you, Leslie and Nick, for your respective presentations. Nick has sowed the seeds for an interesting discussion on AI to take place at the end of the formal presentations. We shall now move on to the next topic and look at the latest test for apparent bias in litigation and arbitration. It is axiomatic that a judge or arbitrator must be impartial. He or she must not be biased in favor of or against any party in the litigation or arbitration. An arbitrator who is not in fact biased must not give the appearance of bias. In short, justice must be seen to be done. The UK Supreme Court's judgment in Halliburton Company and Chubb Bermuda Insurance Limited was released at the end of last year, and it is the most significant decision on English arbitration law in a decade. Halliburton is now the leading English law decision on arbitrator conflicts. it has refined the litmus test of apparent bias in English law and for arbitrators sitting in England. We're extremely privileged today to have none other than the lead counsel who appeared before the UK Supreme Court. Nick appeared successfully on behalf of the LMAA as interveners in stressing the distinctive feature of maritime arbitration. He was successful in persuading the UK Supreme Court to follow the IBA guidelines exception to maritime arbitration, where an arbitrator may be appointed as arbitrator on 2 or more occasions over the last 3 years by one of the parties, subject, of course, to disclosures. Nick will highlight the important parts of the Supreme Court judgment in Halliburton, which actually deals with different heads of apparent bias. We shall then hear from Leslie, who shall explain the Singapore Court of Appeal decision of BOI and DOJ, which restated the test for apparent bias in Singapore. I now invite Nick to give his presentation. Nick, platform's yours.
Thank you very much indeed, Colin. Thank you to the SCMA for this wonderful opportunity to speak to so many people in so many places. It would be lovely to be in Singapore, but that is not possible at the moment. And I suppose the flip side is doing it all online does mean people from lots of different places can come together. So I'm going to talk about Halliburton, as Colin says, a Supreme Court case about removal of arbitrators for apparent bias, decided last year after a year's delay, actually, just over 12 months delay from the final word spoken in argument to the decision, which may perhaps indicate that it wasn't altogether straightforward. And as Colin said, I represented the LMAA, the London Maritime Arbitrators Association, as interveners, which was a great privilege. And it was also, I should say, a great privilege to be assisted by my junior, Mr. Andrew Stevens of Four Pump Court, who I'm sure many of you will know, who did most of the work and had most of the ideas. Anyway, I want to focus on the 2 most fundamental points which Halliburton dealt with and decided. And they are, firstly, what is the test for removal of an arbitrator on the grounds of apparent bias? It's a first question. And the second question, which is obviously very closely linked to it, but you can't answer until you've asked the first one, when does an arbitrator have a duty to disclose some undisclosed fact that might be relevant to a complaint of apparent bias? Now, before telling you what the Supreme Court said about those 2 issues, two preliminaries. First, the kind of the boring one, the facts, but we do need to just have at least an outline of the facts to understand what the court was dealing with. So I'm going to give you an abbreviated and rather simplified version of the facts. The arbitrator, Ken Rokerson QC, very distinguished, a very well-known arbitrator, was appointed by the court in a Bermuda form arbitration between Halliburton and Chubb, an insurance arbitration arising from the Deepwater Horizon disaster. Note that he was appointed by the court. That's because the 2 parties couldn't agree on a third arbitrator, so you might feel trouble was brewing already. They had to get the court to appoint him. And Ken Rokerson was one of the arbitrators suggested as appropriate by Chubb. So it wasn't Chubb's appointment, but he had been suggested by Chubb and the court agreed. So that's arbitration number 1. Then there's a subsequent arbitration. In fact, there were 2 subsequent arbitrations, but I'm simplifying. There was a subsequent arbitration between Chubb and another party, and Chubb appointed Mr. Rokerson as their appointed arbitrator. And Mr. Rokerson told the parties in arbitration 2 about his appointment as chair in arbitration number 1, but he didn't go back to tell Halliburton in arbitration number 1 about his appointment by Chubb in arbitration number 2. And it was that caused the problem, because Halliburton found out, and they said in arbitration number 1, Mr. Rakeson, you should resign. But Chubb said, no, you mustn't resign. So the court had to decide. And the complaint was that although Mr. Rakeson wasn't actually biased, the court should find that he gave the appearance of bias. There was apparent bias. So it went to court. It went to court in London, because that was the curial court, because it was a London-based arbitration. And at first instance, the court said there was no duty on Mr. Rakeson to disclose. He hadn't breached any duty, and therefore he wouldn't be removed. The Court of Appeal took a different line. He should have disclosed, but even though he didn't disclose, he shouldn't be removed. And spoiler alert, the Supreme Court essentially agreed with the Court of Appeal, and they too said, actually, he should have disclosed. He had a duty to disclose, which he didn't comply with, but in the circumstances, we're not going to remove him as arbitrator. So it is a case about multiple appointments by the same party in an overlapping subject matter arbitration. Second preliminary point, a reminder, it is a vanilla case in a sense, because Bermuda form arbitration, there were no arbitral institution rules saying anything about disclosure. And please remember, if you have problems, cases like this, the first place to go to is the institutional rules. So to take an arbitral institution entirely at random, the Rule 15 of the SCMA rules deals with duty to disclose, and an arbitrator must disclose any circumstances likely to give rise to justifiable doubts as to his impartiality or independence. If I may say so, an extremely good rule, which is almost entirely consonant with the Supreme Court decision. But remember that Halliburton is the vanilla case. It's obviously English law case, but it's also the vanilla case because no rules. So the first of the two key points, what is the test to be applied when there's a challenge on the grounds of apparent bias? Easy, as long as you remember that the person you must think about is the informed, fair-minded observer. I call that person IFMO for short, because I can't remember it otherwise. Informed, fair-minded observer. A bit like the man on the top of the Clapham omnibus who doesn't really exist and is a figment of our imagination, but here's a new legal figment, the informed, fair-minded observer. But that person, he or she, is objective, not unduly sensitive, and will take a view on an informed basis of whether there is a real possibility of bias. So the test is, would IFMO conclude that there was a real possibility of bias, but wait for the next bit, having regard to the realities of international arbitration and the customs and practices of the relevant field of arbitration. Now, that's the important bit, because it makes everything a little bit context dependent, and I'll come back to that in a minute. And that test is to be applied as of the date of the application to remove the arbitrator. So what can we say about that? I think three things. First of all, it's the same for all arbitrators, whether they're appointed by the court, whether they're party appointed, whether they're a chair appointed by the two wing members. Same rule for everybody. Secondly, that is the test is not really surprising. It's the same as Porter and McGill says the test is in court proceedings. And it's essentially the same as the Arbitration Act test for removal of an arbitrator. The difficulty in application comes because of the reference to customs and practices of the particular field of arbitration, and I'll come back to that. So once we know when somebody will be removed, we can ask the question, what does an arbitrator have to disclose? Is there a legal duty to disclose? And if so, exactly what is it? And the Supreme Court tell us, contrary to the decision at first instance, yes, there is a legal duty. It arises out of the duty imposed by Section 33 of the Act to act fairly and impartially. Now, if you think about it, it might be put as a duty to disclose circumstances which would give rise to a finding of apparent bias. That might be the answer, but it isn't. The answer is a little bit wider. It is a duty to disclose facts and circumstances known to the arbitrator, which would or might lead IFMO, our friend, the informed fair-minded observer, to conclude that there was a real possibility that the arbitrator was biased. I'll say that again. A duty to disclose facts and circumstances known to the arbitrator, which would or might reasonably lead IFMO to conclude that there was a real possibility that the arbitrator was biased. So 3 points to note. There's a kind of double subjunctive. Would or might lead IFMO to conclude, and only that there was a real possibility of bias. So not would lead IFMO to conclude that the arbitrator was biased, but might lead IFMO to conclude there was a real possibility of bias. Second point to note, the question is to be asked as at the time the disclosure could or should have been made. Third point to note, the rule is expressed in terms of information known to the arbitrator. Fourth point to note, because the test is broader than the test for apparent bias, obviously, therefore, there can be cases where the arbitrator must disclose, but having disclosed does not need to stand down. And fifthly, and this is a bit of a brain teaser, the fact of non-disclosure by an arbitrator of something that he ought to have disclosed, that mere fact of non-disclosure is something that IFMO might take into account in deciding whether there was a real risk of bias. In other words, things are made worse by the failure to disclose. And that, I would suggest, must surely lead all of us who are arbitrators to the conclusion, if in doubt, disclose. Now, for all of us operating in the maritime field, perhaps the most critical question is there's something different about maritime arbitration. And of course, if you go back to the test for bias, it's would IFMO conclude there was a real possibility of bias, having regard to the realities of international arbitration and the customs and practice of the relevant field. And it was because of concerns that the LMAA felt that maritime arbitration is in some ways different, that they chose to intervene. And the short answer to my question is yes, the Supreme Court accepted that maritime arbitration was a bit different. They said this, it's at paragraph 91. As the LMAA has shown, it is an accepted feature of LMAA arbitrations that arbitrators will act in multiple arbitrations, often arising out of the same events. And sometimes there are chain charter party disputes, things like that. Parties which refer their dispute to their arbitrations are taken to accede to this practice and to accept that such involvement by their arbitrators does not call into question their fairness or impartiality. So the Supreme Court is saying that there are some circumstances which in a, let's say, an ICC international commercial arbitration might give rise to the appearance of bias, but would not in maritime arbitration, essentially, I think, because maritime arbitration is quite a closed and specialized community, and also because some of the types of dispute that we deal with often give rise to multiple arbitrations. At paragraph 135 of the Supreme Court decision, a good bit of advice, particularly to maritime arbitral institutions. Rather, said the court, than have disputes about the existence or absence of a duty of disclosure by proof of general custom or practice, there may be merit in putting the matter beyond doubt by express statement in the rules or guidance of the relevant institution. In other words, words, if you think that in maritime arbitration there is a more restricted duty to disclose, it might be as well to make that explicit in rules of guidance. The Supreme Court decision certainly does not answer every question. Let me give you two things to think about finally. What about multiple appointments, not by the same party, but by the same firm of solicitors? Does there come a point where the fact that arbitrator X has done 100 of his 120 arbitrations to date on appointments coming from solicitors firm X or Y mean that there is apparent bias? And if so, how many appointments can he or she take from the same firm of solicitors before there is a duty to disclose? And I'll leave you with a final question to ponder. What if arbitrator Mrs. A in the first arbitration has decided a point of construction on, say, a standard form contract in a case between X and Y? And arbitrator Mrs. A is appointed in another case, this time between X and Z, where the same point arises. So party X already knows Mrs. A's views on this point of construction, knows the arguments which were attractive to her in the first arbitration. Whereas the opponent, party Z, doesn't even know that Mrs. A has decided this point in the past. Does Mrs. A have to disclose? Not, I think, an altogether easy question. Anyway, that's my trot through Halliburton and my observations on some of the points to which it gives rise.
Hello again,
Leslie.
folks. I think it's my pleasure and privilege to make some comments and observations to what Nick has just so masterfully painted for us. First of all, I think when I first read the decision of Halliburton, I thought it was very timely, particularly on the point of disclosure for the arbitration world. At least a leading jurisdiction like London has made it very clear that there is a duty to disclose. And to pick up on what Nick pointed out, good rule of thumb, when in doubt, disclose. And I think most of us in the who practice arbitrators do generally take that approach, because nothing could be worse than spoiling the whole dispute process by something that we are remiss in. Let me then quickly make 3 points or 3 observations. One, of course, it behoves me to point out that in Singapore, we have BOI, BOJ, which is not an arbitration case, but a challenge against a judge. So more Porter McGill kind of situation. By contrast to Halliburton, I thought that, speaking for myself, the Singapore case of BOI and BOJ was a little bit more ponderous because it attempted to do a survey of several jurisdictions, including England. But this predates Halliburton. BOI, BOJ was 2018. Halliburton is very recent. And then, of course, as I said, it deals with recusal of a judge. And to make matters worse, BOI, BOJ, for those of you who are not familiar, the context was a divorce proceeding. So, it couldn't get worse. Everybody's slinging mud left, right, and center. It really literally muddies the whole dispute. But kudos to the apex court in Singapore. They managed, as usual, to unravel the thing. The second observation I'll make is that the test for apparent bias, while it is tempting to say there's a difference, I would venture to suggest that there's very little difference between England and Singapore. The words used in Halliburton and other cases in England is real possibility of bias. Singapore chooses the phraseology of reasonable suspicion. I think it's a case of linguistic limitations. And I find Halliburton helpful by putting in the forefront, and this one I must compliment Nick, by putting in the forefront IFMO, right? The informed, fair-minded observer. Now, I think it's great to have something like IFMO, because I think the essence of apparent bias, and indeed any kind of measurement of bias, is about fairness, really. And that must be the substratum of what we're trying to do. It's being fair to the parties and being fair to the process. And so I think that's what I take away from Halliburton, putting that in the forefront. Now, BOI, BOJ decided in 2018, 2 years ahead of Halliburton, interestingly enough, drew on Potter and McGill and actually looked at the fair-minded observer as the objective observer, using that as a test. The third point I'd like to make is, again, what Nick has very helpfully pointed out, that in maritime arbitrations, the Supreme Court in UK recognized that and accepted LMA's arguments, Nick's arguments, that maritime arbitrations are slightly different. There are customs and practices, and it is a kind of a closed class, if you like, that makes the difference in terms of how you address the issue of apparent bias. I would say that that's a very, very good approach to take, not only for maritime arbitrations. There are many other industries which will, when they end up in disputes, will have to rely on the context. And I think in disputes world, those of us who've been practicing for a long time will indubitably over time realize that many things that we do is contextualized and must take into account practices peculiar to either the industry or the dispute itself. And again, I'd like to kind of use Nick as a jumping off point, his comment as a jumping off point. Yes, we are dealing with judgment, and judgment has to be tempered with what we see in realities. So I think the point observed by UK Supreme Court about taking into account the realities is wonderful. The last point and the final point I'd like to make is really a plug to say that while Singapore has developed its own jurisprudence over the last 25 years, perhaps, it is still very much owes its genesis in English law. And so the IFMO thing jumped out straight away to me when I read both decisions, even though BOI, BOJ was decided before Halliburton. And I think we can both, those of us practice in either or both jurisdictions, can take comfort in the fact that both our jurisdictions take a principled and logical, rational approach at looking at things. And I think that's the essence of dispute resolution, and indeed, to use somewhat cliched phrase, the essence of justice that parties are looking for. So thank you, Nick, for your, those would be my observations. Over to you, Colin.
Thank you, Nick and Leslie, for your lucid presentations on the test for apparent bias in Singapore and England. We can see that the both jurisdictions have developed tests that are quite closely aligned to each other. But now, lastly but not least, we have a very interesting topic today, and that is electronic bills of lading and the impact of recent changes to the Electronic Transactions Act in Singapore. Now, in 2017, Arbitral adopted the model law on electronic transferable records, Mletr, and Mletr aims to enable the legal use of electronic transferable records, both domestically and across borders. It applies to electronic transferable records that are functionally equivalent to transferable documents or instruments, which tend to be used in international trade. So for example, bills of lading, airway bills, bills of exchange, promissory notes, etc. Singapore has become the second country to adopt the Arbitral model law on electronic transferable records as part of the legislation. So Until the recent amendment of this Mletr, the Singapore Electronic Transactions Act, which has been enforced since May 2010, had rather limited applicability towards the recognition of towards some other forms of bills. It only recognized electronic signatures and records, but promissory notes, bills of ladings, and bills of exchange fell outside the ambit of the Electronic Transactions Act. So with the adoption of the new Arbitral model law on electronic transfer records, this now brings those instruments within the scope of the Electronic Transactions Act. Kenny shall explain to us how the recent change to Singapore law would impact upon international trade and the maritime industry. And so after Kenny's presentation, Nick shall offer his views on the same subject matter. I now, Vasanti would offer her views on the same subject matter. I now invite Kenny to give his presentation. Kenny, the platform's yours.
Hello, everyone. Thank you. Thank you for taking the time to attend this webinar. My presentation today is on electronic bills of lading and the impact of recent changes to the Electronic Transaction Act in Singapore. My presentation today will be in three parts. First, I'll give an introduction on the law on ETR, that is electronic transferable record, which includes electronic bills of lading or EBLs. Okay, secondly, I will highlight the key changes that have been made to the Electronic Transaction Act, or ETA for short. And thirdly, I will share some of my views on the impact of these changes on electronic bills of lading. So let me start with the first part of my presentation, which is the introduction. Okay, so what changes were recently made to the ETA, Electronic Transaction Act? So in essence, the ETA was amended to give effect to Arbitral model law on electronic transferable record, or MLETR for short. So what is the MLETR? Let me start by explaining Arbitral. Arbitral is the United Nations Commissions on International Trade Law. And one of the objectives of Arbitral is to harmonize trade law. And to do this, they've come up with a set of laws which they think would be universally accepted by all countries. And they call this model law. Now, if every country were to enact this model law, then there would be the harmonization objective would be achieved, because it doesn't matter which country you're in, the law will be the same. Okay, so in the present case, Arbitral has come up with a set of model laws on electronic transferable record called the MLETR. And Singapore, being a good and supportive member of the UN, has decided to enact this model law as part of Singapore law by amending the Electronic Transaction Act. And this amendment to the ETA came into effect earlier this year, and the ETR is now in operation as of 19 March 2021. Let me provide you with some key facts regarding MLETR. Singapore is the second country to give effect to the MLETR. Bahrain was the first, and apart from Bahrain and Singapore, Abu Dhabi has also adopted the MLETR. Now, most of the key provisions of the MLETR have been adopted by Singapore in the Electronic Transaction Act. Now, in adopting the MLETR, Singapore has also made some modifications to the MLETR provisions, and this is allowed under the MLETR. And during my presentation, I'll try and highlight to you what some of these modifications are that have been made by Singapore. Now, Singapore gave effect to the MLETR by amending the Electronic Transaction Act instead of enacting a new and separate statute. Okay, so now the MLETR is contained within the ETA itself under a new Part 2A of the ETA. Okay, now I move on to the second part of my presentation, which is to highlight the key changes introduced by Part 2A of the ETA. Now, Part 2A of the ETA is made up of 6 divisions, and I'll try and highlight the key provisions from each division. Division 1, the first division, this deals essentially with the scope of these new rules or provisions. Basically, the question here is, what documents do they cover? Now, before the ETA was amended, one group of documents was excluded, namely negotiable instruments, documents of title, bills of exchange, promissory notes, consignment notes, bills of lading, warehouse receipts, and any other document which are essentially document of title. All these have been excluded previously. Okay, so when the ETA was amended, they deleted this list of excluded documents. Now, what this meant was that all of these previously excluded documents are now covered by the ETA. However, not all of these documents fall within the definition of transferable document or instrument. If you look closely at the provisions, you will see that the definition of transferable document or instrument includes bill of exchange, promissory note, and bill of lading, but does not include consignment notes and warehouse receipts. And this is because under Singapore law, it is somewhat doubtful whether consignment notes and warehouse receipts are regarded as documents of title. Now, the net effect of this change is that you can have consignment notes and warehouse receipts as an electronic record, okay, under the ETA, but they will not be treated as transferable document or instruments, okay, unless you, of course, you satisfy the definition, okay. I move on now to Division 2. Division 2 concerns functional equivalence. Okay, this very important concept in the context of the MLETR, because the main objective of the model law is to ensure that ETRs, electronic transferable records, are not denied effect solely on the ground that is in the form of an electronic record. Now, to ensure that this objective is achieved, the MLETR uses the concept of functional equivalence. In other words, if you can show that the electronic document functions in the same way as the hard copy document, then the electronic document would be deemed acceptable. So for example, if there's a requirement for a signature, what is the functional equivalence of a signature? Well, you need to identify the person who signs and show that this person is able to indicate his intention through the act of signing. Now, if you can fulfill the function of signature electronically, then this would be considered acceptable. Now, the main pillar of functional equivalence is the concept of a reliable method. Okay, so a typical provision on functional equivalence would read, where a rule of law requires something, let's say in this case, a signature of a person, that requirement is met with respect to an electronic transferable record if a reliable method, okay, is used to, and then it sets out the requirements to be satisfied for purposes of achieving functional equivalence. So in the case of a signature, it would be to identify the person, and B, to indicate that that person's intention in respect of the information contained in the electronic transferable record. Okay, so it's a three-part thing. Okay, so first, what is the action that you require? Let's say you are you talking about a signature, endorsement, requirement for writing? Okay, and then what is the functional equivalence of doing that in the electronic space? Okay, and the thing that's connecting these two is what we call the reliable method. You must have a reliable method to show that you are able to satisfy the requirements, okay? And if you are able to do so, then essentially you have achieved functional equivalence, okay? Now, the idea of a reliable method is central to the concept of functional equivalence. All the provisions relating to signature, writing, possession, etc., all depend on whether a reliable method can be used to achieve functional equivalence. Let me take a look at another example, transferable document or instrument, or it's in other words, bill of lading. Okay, so an example of a transferable document or instrument is a bill of lading. So where a rule of law requires a bill of lading, that requirement is met by an electronic record if the electronic record contains the information which would be required to be contained in the transferable document or instrument, and a reliable method is used to identify the electronic record as the authoritative record, constituting the electronic transfer record, to render the record capable of being subject to control, and finally to retain the integrity of that electronic record. So if you're able to fulfill all these requirements, then in essence, you would have achieved functional equivalence for a bill of lading. Okay, let me move on to the next division, Division 3, and this concerns the use of electronic transferable record. The question here is, if you have a hard copy bill of lading, can you change it to electronic form and vice versa? So the short answer there is yes, you can do it under the provisions of the amended Electronic Transaction Act. Division 4 concerns the general reliability standard, right? So this ties in with what I've been talking about, the reliable method, okay, being the main component of functional equivalence. Now, the meaning of a reliable method is defined or set out in Division 4, and basically the reliable method must be as reliable as appropriate, okay, to fulfill the function for which the method is being used in light of all the relevant circumstances. Okay, so that's the first one. I'll come back to what are the relevant circumstances in a short while. And the second part is if you are able to prove, in fact, to have fulfilled the function by itself or together with any further evidence. Okay, so it's either or thing. Okay, so just now I made reference to relevant circumstances. Okay, what are the relevant circumstances for you to look at to determine whether you fulfill the function of a reliable method? Okay, these include operational rules that are relevant to assessment of reliability, the assurance of that data integrity, ability to prevent unauthorized access, security of hardware and software, and things like regularity and extent of an audit by independent body, the existence of declaration of by a supervisory body or accreditation body, and any other applicable industry standards. So these are all the circumstances which you can look at. Okay. Now, in adopting the MLETR, Singapore made one key modification to Division 4, and that is they added a new provision which says that if you use an accredited system, it is presumed that the method used by such accredited system satisfies the reliable method requirement. Okay, but of course, the presumption only applies if the provider of accredited system remain accredited. Okay, so that is Division 4. I move on to Division 5, which deals with cross-border recognition. 2 points to be made here. First, an ETR will not be denied legal effect just because it is issued or used outside Singapore. And second, the model law does not affect any rule of private international law. So what this means is that the model law does not displace existing private international law applicable to paper documents. Okay, such laws are considered substantive law for the purposes of model law. The last division is Division 6, and that's on the accreditation, which I mentioned earlier. This entire division is added on by Singapore. It does not appear in the MLETR. Now, under this division, the minister may make rules relating to accreditation. Now, as far as I'm aware, these rules have not been made yet and won't be made anytime soon. So until they've been made, if you want, so you basically, you can't use accreditation for the purposes of proving a reliable method, okay? You have to use one of the other relevant circumstances, which I mentioned earlier under Division 4. Okay, so that concludes in very, very brief terms what the Act is about. Let me move on now to a third part of my talk, which is to discuss the impact of these changes. Now, what impact can we expect now that the ETR has been amended. Now, first, we expect to see greater use of EBLs because of the benefits of using EBLs. What are the benefits of using these EBLs? Well, I can name a few. First, it should be faster for you to transmit EBLs as compared to paper BLs. At the press of a button, you basically can send electronic bills of lading halfway across the world. Secondly, EBLs ensures accuracy as compared to paper bills. When EBLs, with EBLs, you can basically transfer data from one system to another, but with paper BL, you need to manually key in the information and run the risk of making mistakes. Thirdly, EBLs are said to be environmentally friendly because you don't use paper and you save the trees. But of course, some would argue that you still need to generate electricity for EBLs, and generating electricity by conventional methods may not be environmentally friendly. Fourthly, it's supposed to be lower costs, no paper, no printing, no courier charges. Fifthly, it's supposed to be more secure. I'm told that EBLs are more difficult to forge as compared to paper BLs. And lastly, EBLs are easier to store and retrieve as compared to paper BLs. For paper documents, essentially, if you may need to send it to the warehouse, but you don't have that issue with EBLs. Now, what else can we expect now that the ETA has been amended? Now, for those of us involved in dispute resolution, we like to see more of bills of lading providing for Singapore law and Singapore litigation or arbitration. So if you use an EBL that provides for Singapore law and Singapore litigation or arbitration, you can expect the Singapore court or tribunal will recognize or enforce the EBL under the amended ETA. Okay, so I would strongly encourage those of you who may be exploring EBLs to consider adopting Singapore law and Singapore litigation or arbitration, because you know for sure that with the passing of the Act, that EBLs will now be recognized and enforced as a matter of law. Okay, going now to the final point I want to make, I want to pose some questions, okay, of situations where what if you have an EBL that provides for Singapore law to apply, but for disputes to be resolved at a forum. Okay, would the foreign court or tribunal recognize the EBL? Well, I think this is an issue for the lawyers from the foreign jurisdiction to advise, and we have some in the panel today, so perhaps they can express some of their views on this point. Okay, the other way of looking at this is, what if it was the other way around? So you have an EBL which provides for foreign law and Singapore forum. Will the Singapore court or tribunal recognize the electronic bill of lading? Okay, from what I know, the answer to this question is not straightforward. There are various possibilities. Okay, you can, is it a question to be decided at the place where the bill of lading is issued? Or do you decide this issue based on where the endorsement or delivery take place? Or do you decide this based on the law chosen by the parties? Now, I don't have any concrete answer, but based on what I understand, there's academic support for the law chosen by the parties to govern the bill of lading or contract of carriage. But in any case, as I said, if you do not want to take any chances, I would suggest that it would be best if you could provide for both Singapore law and Singapore dispute resolution in the bill of lading. Now, with this, I conclude my presentation. Dr. Ong, over to you. I'm sorry. I think it's back to Vasanthi.
Thank you very much, Kenny, for that very clear and informative presentation. Can I first of all say that England is slightly behind the Singapore curve because we don't yet have an equivalent piece of legislation in force dealing with electronic trade documents. Obviously, Singapore's experience and the legislation that it's enacted will be particularly relevant in connection with an ongoing consultation process in England. On the 30th of April of this year, the Law Commission of England and Wales issued a very lengthy consultation paper on digital assets and electronic trade documents. Now, that consultation paper reviewed the current law in England and Wales and concluded that there was a case to be made for reform to allow electronic trade documents to have the same legal effects as their paper counterparts. Now, the consultation paper reviewed the solutions which had been adopted in other maritime jurisdictions. And they specifically mentioned Singapore as being particularly relevant to the model that English law may in due course choose to adopt to facilitate the use of electronic trade documents. Now, the consultation paper attached a draft of an electronic trade documents bill, which is expressed to make provision for trade documents in electronic form to have the same effect as trade documents in paper form. It's a very short bill. It consists of 6 clauses. The first clause contains definitions of trade document, which includes a bill of lading, as well, interestingly, as a warehouse receipt and a ship's delivery order. It includes definitions of electronic trade documents, which is a document that is in electronic form, contains information that would be required to be contained in the equivalent trade document in paper form, and is held by means of a system that secures that no more than one person has control of the document at any one time. And after the document is transferred from one person to another person, the transferor no longer has control of it. And it also defines the concept of control. It says a person has control of a document if that person is able to use the document and transfer or otherwise dispose of it. Other clauses deal with possession of electronic trade documents, replacement of trade documents, and contains provision for a power to amend the definition of a trade document. Now, if anyone would like a copy of that consultation paper after the event, then I'll certainly provide that to the SCMA and they can provide it to you. Now, it's unclear how long it will be before we have legislation in England implementing the results of the consultation, but it's certainly coming, so watch this space. Thank you.
Thank you very much, Kenny Vasanti, for your respective presentations. We now open the panel. If I could have all panelists open their cameras. And first question comes from Alexandra Hurst. And her question is, with regard to accreditation in Singapore of electronic trading systems, would approval by the international group of P&I clubs suffice as an example of accreditation? Kenny, can I put that first question to you, please?
Sure. Thank you, Colin, and thank you for that question. It's a very, very good question, I must say. Okay. Now, as I didn't touch upon P&I club approval in my talk, simply because there's so much to talk about in terms of e-bills, bills of lading. But essentially, if you, there are people out there in the audience who are looking to sign on to some electronic system, one of the points you need to consider is whether that system has been approved by the international group of P&I clubs. Okay, and if it's not been approved, then what that means is that you don't get club coverage for that. Okay, so now your question is slightly different in the sense that, would approval by the club, okay, amount to satisfying the requirement for accreditation. Let me first say that accreditation is a different process, but what you actually want to do is satisfy the requirements for a reliable method. Okay, so if you can, and the thing with the Division 4, which defines reliable method, is that you have to look at a whole range of relevant circumstances. Okay, I read out a long list of relevant circumstances to you just now during my talk. And essentially all these circumstances all have to do with how good or how secure, how strong is your system, okay? And one of the points that is you can take into consideration is whether there's been declaration by a supervisory body, okay, regarding the reliability of the system, okay? So if the IG group has looked at your system and they can say that, you know, this system is a reliable system and therefore we approve it, then to me that is a very relevant circumstances which you can use for purposes of satisfying the reliable method requirement under the Act. I hope I've answered that. Back to you, Dr. Ong.
Thank you, Kenny. Nick, a question for you from Karina Song, and her question is, as it is an accepted feature of maritime and trade arbitrations, that arbitrators will act in multiple arbitrations arising out of the same set of facts. Do you think it would be useful for there to be a set of international guidelines to be produced to provide some guidance to the international maritime and trade community?
Well, thank you, Karina. That's a good question and quite a probing question. And the first half of it is kind of directed to multiple arbitrations arising out of the same facts, which is an issue which Halliburton dealt with. The second part of it touches on that slightly different question which I raised, which is arbitrator appointed by the same solicitor or firm of solicitors. I think the answer to your question, should there be guidelines, probably comes down to whether, broadly speaking, you think that things are better decided case by case on a sort of precedent basis, or whether you think it is helpful to have guidance. I must say, I tend to think it is an issue where some guidance would be helpful, but I think it has to come from the institutions, probably. I think I think getting everybody to agree with some sort of overarching international guidance is probably pie in the sky. Even if you look at the IBA guidelines, they have some carve-outs. And I think that the problem is that the culture of arbitration is different in different places, different in different fields. And so I think if we're going to get guidance, we've got to look to the institutions. That would be my feeling.
I think I would agree with that, Nick. I think there's just too much soft law around, and they can be used for all sorts of challenges. But can I hear from the other panelists? Do any of you have any comments to that last interesting question? If not, Vasanthi.
Yes, I mean, I agree with Nick's observations, but I think one other factor that we may need to take account of now moving forward is whether custom and practice may start changing, where arbitrators who sit in maritime but also in other fields may start adopting the practices that they have in other fields to bring about consistency in their disclosure. And once custom and practice starts to change, query whether the justification for treating maritime as a separate will persist.
Thank you, Vasanthi. Questions come in for Leslie. Leslie, how would advocates have to adapt in the presentation of their cases, if any, in the digital age?
Thank you for that question. I think that the most important aspect in terms of what we do as lawyers would be in the context of advocacy. Clearly, in recent times, we've seen how you have to make your presentations to a screen, to a camera, rather than living persons. I think that does mean that there needs to be some idea of how you deal with that kind of inert processes compared to a more interactive, more live kind of situation, as it were. Currently in the university, we run courses on advocacy, and we are looking at this particular area. Clearly, that will have to change. The other aspect is what Nick mentioned, and that is to make sure that as advocates, we are clued into all the various aids that are available for us that will make our lives better and our presentations better. Certainly, many of you, so I would imagine, and I know for a fact that many of you would have used these various digital aids, as Nick has mentioned, not only just preparation of the case, but in a live presentation of the case. There are a lot of tools that can be used. So I think that's how it will impact. The last point is, of course, pretty much my thesis of what I was trying to convey, perhaps not so successfully, is that we do need to think about how technology will continue to impact what we do and join in the discussion to influence it. Because what I fear is that being lawyers and people in the law, we're kind of traditionalists, and we kind of leave it to others to tell us when they are ready, as opposed to getting into the conversation. And I would like to see many more of us get involved in the process of the building of these technological structures. And I said the last point, but perhaps another related point, which I'm also pretty much very passionate about, is that we need to get involved in the whole technological process in order to influence two other things. One is the duties and obligations to clients, and Nick touched a little bit on the privacy and confidentiality, but more importantly to me, the ethics that are sometimes forgotten. Programmers are not necessarily concerned with these things. We need to get involved in that conversation, I feel.
Thank you, Leslie. One last question. Edwin Wong asked Kenny, is the technology that you mentioned earlier, does it make use of blockchain technology?
Okay, the short answer to that is not necessarily. Okay, the Act is what we call technology neutral. Okay, it doesn't favor one form or type of technology over the other. So you can use blockchain, you can use some registry system or whatever system that you want to use. Okay, it's technology neutral. Okay, but of course it can accommodate blockchain if you satisfy all the relevant provisions of the Act.
Thank you, Kenny. Actually, there is one question that's come in for Nick. Nick, in your view, were there any missed opportunities in the Supreme Court's decision in Halliburton?
Missed opportunity might be putting it too high, but one thing which I think was a shame was that all of the discussion and debate in Halliburton was directed to disclosure driven by the risk of apparent bias. And I think it is important not to overlook the possibility that sometimes as an arbitrator, you may need to disclose something, not because of apparent bias, but in order to ensure that the proceedings are fair. And that question I posited right at the end, which was, suppose you're an arbitrator, you've decided a point of construction before, the same point of construction arises in a subsequent arbitration. You know as arbitrator that one of the counsel appearing in front of you knows what you decided before because they were in that case, and the other counsel in front of you doesn't even know you decided the point before. This is something that's got nothing to do with bias, but my feeling is that if those proceedings are to be fair, the arbitrator ought to disclose that. Because after all, if a judge decides a point, everybody appearing in front of him knows that he's decided this point before. It's the first thing we do, isn't it? We know who our judge is. We find out what they've decided in the same area before. So I think because the focus was entirely on bias-driven disclosure, there's a risk that we forget that there may be other reasons as arbitrators that we need to disclose something. So that would be my kind of don't forget that there may be another reason to disclose. Got nothing to do with bias, because I think as arbitrators we sometimes think, well, of course we won't be biased. How could anybody think we'd be biased? We're not biased. So and then we don't think maybe a little bit further. Maybe there's a different reason why I must disclose something.
Thank you for views, Nick.
Colin, if I may, sorry for interrupting. If I may add on to what Nick suggested.
Please do.
Yeah, I couldn't agree more with Nick. But what I would add is, I think it behoves all of us as adjudicators, particularly arbitrators, to think more of the process and not just what's in front of us. And the process of arbitration is, to me, a remarkable mechanism. Its success is just amazing to me. That there's no supervening authority, there's no published judgments, and yet, by and large, all of us get it right, as it were. And I think we get it right simply because we subscribe to the idea that we're doing something worthwhile, and it's got to be right and fair in the eyes of people who use the process. So I think, Nick, you are absolutely spot on. I don't think I don't think it's putting it too high that was a missed opportunity. I think it would have been very good if UK Supreme Court could have just shifted a little bit and reminded everybody that, you know, apparent bias disclosure is much more than what we are considering with, because it really goes down to the issue of fairness.
Thank you, Leslie. Can I now ask all attendees to whip out your phones and take a look at this QR code that's coming up? If you can please give us your feedback, that would be very helpful. Thank you. Thank you very much. So now it just bears on me to draw this webinar to a close. And I would like to thank all our 4 speakers for sharing their views and their valuable time in giving us their knowledge. So thank you very much. And thank you to all attendees for attending. And last but not least, thank you to the SCMA staff for making this webinar possible. So thank you very much. And I know it's not yet the weekend, but do have a good weekend. Thank you.